Good morning, and thank you for joining us.
We provide bold,
legal insight and business leadership
to forward-thinking people and organizations.
We believe in better
and bold outcomes
and meticulous focus
in finding the solutions others might miss.
By building our practice around the best minds in the legal profession.
And outside of it, too. We believe the pursuit of better starts with people.
Our colleagues, our clients,
and the people who depend on them.
We are committed to truly understanding
the individual needs
of those who depend on us,
so we can help them go from where they are
to where they want to be.
We are.
We are.
We are.
We are.
We are.
Husch Blackwell.
Husch Blackwell.
Husch Blackwell.
We are Husch Blackwell.
Good morning, and thank you for joining us today. My name is Dan Miskey. I'm a partner at Husch Blackwell, representing condominium and homeowners associations throughout the state of Wisconsin. Joining me today is the co-leader of our team, Lydia Chartre. We'll get to those introductions. Before we begin, I want to cover a few housekeeping items. The bathrooms that we always talk about at presentations are down the hall to the left or right at your house, depending on where you are. At the bottom of your audience console, there are multiple application icons for your use during the program today. You can test them out. Please submit any questions during the webcast via the question box. We will try to answer all the questions during the webcast today, but if a fuller answer is needed, we'll do our best to email to you, depending obviously on the question. A PDF of the presentation, as well as a link to sign up for our blog, is available in the resources folder. This program is approved for Wisconsin Continuing Legal Education Credit and has been approved by the Community Association Managers International Certification Board to fulfill continuing education requirements for the CMCA certification. To report your CMCA hours, click on the CEU icon at the bottom of the screen. A certificate of attendance will be emailed to you tomorrow, along with a recording of the webcast for watching, and you're more than welcome to share it with anyone else you'd like. Toward the end of the program, please be sure to complete the short survey. We use your feedback to plan future programs that are applicable to your association's needs. That's all for the housekeeping items. Let's get started with the program. Today we'll be sharing with you our 10 commandments of association management, shall and shall not do while governing. Joining me is my partner and co-leader of the condo team, Lydia Chartre, who I believe you can now see on the screen, who's also admitted to the College of Community Association Lawyers, which is a select group, about 170 of us throughout the United States who practice significantly in the community association area. Also with me is Kataj Brown, who you'll see in a few moments, who's a commercial litigator focusing on contentious condominium and HOA and business disputes in state and federal court. And our senior paralegal, who many of you know, Sandra Chapman, who focuses on condominium and homeowner association matters. We will begin now.
You're doing the next slide. Okay. Hello, I'm Sandy, and Kataj is joining me as well. And we're going to start out with talking a little bit about collections. Most of you who know me know that that's the area I specifically practice in right now, as well as Kataj. And thou shalt have a collection policy. We feel that everyone needs to have one of these and then follow it. It's going to make your life a whole lot easier if you have that collection policy, and then you can tell your owners we're following the policy and step back. We have one, but we don't follow it. We're the board. We know what we're doing. Not a good idea, because that can really get you in some trouble. And so we really can't stress enough to have that collection policy and follow it. That way everyone is treated equally. So we're going to get started with what you need to know. And Kataj is going to take over that part.
Sure. So now that you've listened to Sandy and your association has a well-drafted collection policy, hopefully drafted by the condo HOA team here at Husch Blackwell, here is what you need to know. The larger the debt, the less likely the owner will pay. Owners are quick to resolve collection matters when the debt is low because there's a greater chance they have the money to pay. This is why we recommend sending delinquent accounts to collections either at the 60 or 90-day mark. At 60 or 90 days, it's only 2 or 3 months of non-payment, and anything longer, you run the risk of the unit owner not only not wanting to pay, but not having enough money to make that payment. On top of late fees, fines, and actual attorney's fees, which in the great state of Wisconsin, the association is entitled to collect in foreclosure lawsuits. Most unit owners don't put up a fight when they know they've missed a few monthly or quarterly payments. However, when fines and late fees are applied on top of several months of missed assessment payments, then their account is sent to collection and the attorney's fees are added. They usually become upset and refuse to pay. And we end up in court, which adds additional legal fees added to the debt. This can usually be avoided by simply sending delinquent accounts to collections at the 60 or 90-day mark when the debt is low. With that in mind, we turn to number 2. An owner is most likely to pay when a collector is responsive. You want a collector who is responsive, fast, and who takes immediate action to keep this collection files moving. The goal of the collector is to either, 1, get the association paid so the money owed can rightfully go back to the upkeep of the association's common elements, or get the association a new owner who will actually pay their assessment or dues on time and will not create a burden on the other owners who have to cover down and pay for the delinquent unit owner's right to live in the community. Again, we recommend a policy that sends an owner's account to collections at no more than the 60 or 90-day past due date. The longer delinquent account lingers, the higher the debt, the more difficult and expensive it will be to either collect or foreclose. Also, when a collector is responsive, the law is on our side. When we go to court and explain an association's collection policy and the fact that the owner has been properly notified and all of the collection policy terms are followed, easily 98% of the time, the unit owner settles the debt while it's low or the court sides with us. However, we have had instances where owner accounts have been sent to us for collections after 6 months to a year of being delinquent. A lot of times at this point, the debt owed is in the high 4 figures and can even sometimes be in the 5-figure range. In those cases, it's difficult to collect because most people don't have the income to drop a large lump sum payment. It's even more difficult to convince a judge to let the association foreclose on a high 4 or 5-figure lien, especially when the owner's first argument will be, well, no one said anything to me about this debt for the last 6 months, so I didn't realize I owed. Trust me, this happens all the time. And as the person who has to convince the judge that the association is threatening to foreclose if not paid, it's an uphill battle when I have to admit that no one from the association said anything to this unit owner for 6 months to a year while the debt, fines, and late fees continue to accumulate. Another consideration is that the debt will only increase if the matter is not settled. This ties back into one of my earlier points. Owners are quick to resolve collections matters when the debt is low. This is because there's a greater chance they have the money to settle or pay off the debt in full. Go to the next slide.
Okay. So now we have a poll question that we'd like you to take a look at and answer. How much does it cost your association if you wait 30 more days to send your $2,000 delinquent owner file to collections? Do you think it's $234, $54, $130, or $1,950? We'll give you a couple seconds to submit that. Time's up. Okay. How much does it cost? So it actually is about $234. And so we're going to go on to what the statistics show. And this is a national statistic. It is a little bit better for the condo world because we do have that statute behind the condominium law. But however, it is pretty accurate with the HOAs. And so when your collection, your debt is paid when it's due, you still have the risk of 91%, 94% recovery. And as you can see from this sliding scale, the 30 days, it goes down a little bit, 60 days, 90 days, then at 6 months, it's almost half. So you can see the importance of getting a debt collected. Now, HOAs, you have a 6-month window. So it's very important in a homeowners association to have that debt taken care of the same year it's due. So you have 60 days after it has been assessed that you cannot lien. Then you have 4 months after that that you can file a lien. So there is only that 6-month window of time. So come the next year, you can't lien for what was due in 2019. You can only lien for what's due in 2020. So keep that in mind for HOAs. Condominiums, it's a little bit different where you can go back 2 years. But as Kataj stressed, we do not recommend that. The higher the debt, the more difficult it is to recover that. So keep that in mind with any delinquencies you may have.
Sure. So what you need to know, as I touched on earlier, when an association delays sending an owner account to collections, that association is literally giving money away. One of the main benefits of living in a community association is the shared cost of maintaining the association's common elements. In other words, no one owns or joins a condominium or homeowners association simply to give money away. However, giving money away is exactly what happens when an association waits and does not take quick, decisive action in sending owner accounts to collection. Board members should remember that each and every time one of their owners is delinquent, the non-delinquent owners are paying for and will continue to pay for the delinquent owners' assessments and share of financial responsibility. Board members need to fight the urge to give their neighbors second chances and additional time to make up for missed assessment or due payments because at the end of the day, all owners are paying for the delinquent owners to continue to live in the association, which they do and will continue to do unless their account is sent to collections and delinquent owners are held accountable. All owners bought into the association. And if one of their neighbors is not upholding their part of the deal, the other owners will end up paying for it. Whether it's through the form of increasing assessments and dues or issuing more frequent special assessments to raise the money to cover for delinquent owners, the longer a delinquent owner's account is not sent to collections, the more money everyone in the community gives away. It's human nature to forgive and give second chances. We get it. Everyone falls upon hard times. And we see many instances where an association board continues to extend time and allowing an owner to pay for missed assessments. However, by graciously giving more time and waiting to send an account to collections, we frequently see what I describe as the domino effect. Because while the first delinquent owner is given additional time to pay, over time, the unit owner's assessments and dues will be increased to counterbalance for the delinquent owner's non-payment. And when the assessments are increased out of the blue, the association is creating an environment where now other unit owners are being put at risk of becoming delinquent themselves because they may not have contemplated the rapid increase in assessment or dues. And now the association has even more delinquent owners. So do not wait. While it may seem harsh to immediately send a neighbor's account to collections at the 60 or 90-day mark, no questions asked, it's for the greater good of the association. Also, as we spoke about before, if your collection policy calls for a specific collections deadline to be enforced, that deadline needs to be strictly followed in order to ultimately recoup all of the costs associated because of the owner's deficiency. So now, what else do you need to know? When is an owner least likely to pay? Number one, we know owners are least likely to pay when the debt is high because they simply may not have the money to bring their account current. Also, large numbers to the right of dollar signs look scary. I can bet everyone on this live stream has opened up a bill and seen a large number to the right of a dollar sign and has immediately become defensive. I know I have. Whether we rightfully owe the money or not, we still get defensive. While on the other hand, when we see a smaller expected number, we are more likely not to challenge the amount owed and simply just pay. Same principles apply here. While the debt amount is small, it is much easier for us to recover. 98% of the time, we send out an initial collection letter on the 60 or 90-day mark. Owners pay to bring their account current. Number two, owners are less likely to pay when the association did not follow its collection policy. Remember, most people are smart enough to recognize right and wrong. And the second someone feels like they're being treated unfairly in the context of condominiums and HOAs, they immediately become self-educated experts on the condominium's governing documents. They will scrutinize every single word of the collection policy to determine if their fines, late fees, or account being sent to collections is justified, and rightfully so. No one wants to get charged extra money, and everyone wants to make sure they are not being unfairly targeted and that the collection policy is being applied uniformly to all owners. More importantly, if the association did not follow its own collection policy, this will be the first, and in a lot of instances, only affirmative defense a delinquent owner and their attorney needs to raise in court in order to counter the association's lawsuit for non-payment. And if the shoe were on the other foot, we would raise that same argument too. My first argument would be, Your Honor, the association is either arbitrarily choosing who they want to fine and sue for non-payment of assessments, or, Your Honor, my client is being targeted because the board doesn't like him or her for whatever reason. Either way, Your Honor, the association board went rogue and didn't even follow or enforce its own collection policy, which is applicable to all unit owners. Your Honor, what the board did to my client is inequitable and under the law is equivalent to breach of contract. And because of that, this lawsuit is frivolous and should be dismissed. And the association should cover both parties' costs and fees for bringing this meritless lawsuit. If I had $1 for every time I heard this same argument raised in court by a delinquent owner and his attorney, based on the fact that the association did not follow its own collection policy, I would be on a beach right now in Sydney, Australia, drinking tequila on the rocks. We hear this argument all the time. And when the association does not follow its own collection policy, there's a good chance the lawsuit filed against the delinquent unit owner will be dismissed, and the association will then have to spend additional money to cover all costs involved. If you do not do anything else, please follow your collection policy. Number 3, owners are less likely to pay when they think they do not have to. Last March, when the court shut down due to COVID and state governors issued executive orders and moratoriums on foreclosures and evictions, a lot of false information regarding payment of assessments was being disseminated. Because of the pandemic and its unknown effects, many people felt they were indefinitely off the hook for paying assessments during this time frame. This is not the truth. The fact that there may have been a moratorium on foreclosures and sheriff sales has no bearing on the fact that condominium and HOA assessments were still due on time and still expected to be paid. As we speak, our team is engaged in lawsuits where delinquent unit owners are showing up in court and telling the judge that they were given advice from some random attorney that they legally did not have to pay assessments during the shutdown. Again, even though the majority of the time that argument should not work, and I say majority of the time because we're finding that many state court judges are very sympathetic to litigants who claim they were adversely affected by COVID. Remember, by not resolving the debt early before ending up in court, the association is now spending even more money to litigate the matter and in turn charging its owners additional money to fund the lawsuit. Number 4, owners are least likely to pay when they feel mad or threatened. Again, it's human nature to become defensive, fight the power, and make a point to resist when we feel mad, threatened, or even disrespected. We frequently find that when delinquent owners are upset, they often simply put their foot down and simply don't pay, which basically forces a lawsuit and the association and its owner to incur even more expenses or argue and go back and forth with the association and its attorneys, which also increases costs and fees. We've had owners resist paying debt owed to the association for almost up to 1 year, simply because they were upset the association had an aggressive fine or late fee policy, or someone on the board threatened a particular unit owner with foreclosure. Mind you, these delinquent owners are not disputing the fact that they own assessments. In many cases, the delinquent unit owner openly agrees they did not pay the assessments because they either did not like the fact they were being fined or they did not like the way the board handled the situation, so they simply resist. In these types of cases, no one wins, because even if the association is ultimately successful in the lawsuit, a lot of money is being spent by the other unit owners to fight the delinquent unit owner in court. This is a lose-lose situation because everyone involved is paying more and more money the longer the litigation drags on.
Thank you, Kataj. Kataj has been a great addition to our team, and as you can see, he's very good at the legal side of things and the court aspects, and he can tell you a lot more stories than he just shared even. Just to recap a little bit, what every association and manager should do. Again, we can't stress enough, have a collection policy. Send that warning letter once the owner's 15 days late. The second warning letter and notice at about 30 days. And let the owner know if you don't pay or make arrangements to pay, you will be turned over to a collection law firm. And at 45 days, you may or may not want to send it at that point, but like we have stressed in the past, don't let it go past 60 to 90 days. But turn it over to the law firm and let us handle it. That's what we're there for, to be the bad guys, because these are your neighbors and you're on the board. You shouldn't have to deal with that. And the manager has to take care of any other requests the owner may have. So let us do that harder work and do the collection part of it. Then what every board member and manager must do.
Right. Yes, I'm going to say it again. Follow the collection policy to the letter. Again, follow your collection policy. I have to say it one more time. Third time's a charm. Follow the collection policy. Again, I cannot stress enough the importance of following your collections policy exactly the way it's written. This is because if a particular collections matter goes to litigation, the court is going to scrutinize whether the association followed its own collection policy to the T. An association's collection policy is included in the condominium or HOA's governing documents, and we all know the governing documents are essentially a contract. If a foreclosure suit is filed, one of the first things a judge will do is analyze whether the collection policy / contract was followed. Big issues are notice, late fees, and fines. Some of the court's analysis will include, was the unit owner notified of late payment in the exact manner that the collection policy states? Did the collection policy state the last chance letter was supposed to be sent out? Is email sufficient for notification, or does the collection policy specify that notice has to be written? Were late fees or fines applied in the exact manner that the collection policy states? Was a lien timely filed? And so on. These are things that a court will look at before getting into the facts of the case. And because a collection policy will be essentially analyzed like a contract, if the association doesn't follow its own policy, most of the time, the court will side with the unit owner and dismiss the lawsuit because the association basically breached its own contract by not following the collections policy. Again, we totally understand that board members are constantly being put in a position where they have to send their neighbors and friends' accounts to collections for non-payment of assessments or dues. And therefore, it's easy to give a neighbor or friend a second chance or cut them a break on fines or notice deadlines. Trust me, we get it. However, if things go left and the unit owner whom someone is given a break to ends up in court in a debt collections matter, if the association's collection policy was not followed, the end result may not be good for the association because it is very difficult to convince a judge to order a foreclosure on someone's home when the very contract that gives the association the right to foreclose was not followed. Number two, After a unit owner's account is sent to collections, to an attorney for collections, stay out of the collections process and do not talk to the unit owner about the debt. One more time, stay out of the collection process and do not discuss the debt with the unit owner. Let us, the attorneys, take the bullet and be the quote unquote bad guys. We will do all of the talking and explaining. Once the collection starts, put your feet up, stay out of it. We got this. Everyone knows their Miranda warnings, right? You have the right to remain silent. Anything you say will be used against you in a court of law. Just like Miranda, we advise the board members to remain silent if approached by an owner regarding debt. Because trust and believe, every single word uttered regarding that unit owner's debt will be used against the association as a defense for non-payment of assessments. We find that delinquent owners dispute the debt amount by always using the excuse that they were told one thing by the board, one thing by the property manager, and then a totally different amount of debt is being collected by the attorneys. They often say the board president waived my late fees and interest, so that's why I didn't pay the full amount of the debt, and I'm not paying a dime more. While the board president in a private conversation may have told the owner late fees and interest were waived, this may not have been communicated to the collectors after the account was sent to collections and documents are filed with the court. Then it's too late. Stories are locked in. The process runs much smoother when the collectors are the only ones who discuss the debt with the delinquent owners. This way, only one voice is speaking on behalf of the association and nothing gets lost in translation as far as amounts owed, late fees, fines applied, and the facts surrounding legal action. Once an account goes to collection, board members and property managers need to remember Miranda, because everything you say will be used against the association by the delinquent unit owner. Trust us on this.
And once you send it, the debtor should have no access to the ledger that is held by the association or the property manager, because it's not going to be accurate during the collection stage. We know what it's going to cost to satisfy a lien or to what is involved should a property go to foreclosure. So please lock them out of access to their ledger. And if an owner contacts the board or the property manager, just say we cannot discuss the debt. Now, if they're calling about a leaky pipe or something else, of course you deal with that issue. But with regard to the debt, just refer them to the attorney. And at the end of the collection, our firm will send you what's called a final ledger, so that you can reconcile your account at the end of that collection. So if we say they're paid in full as of June 30th, and that includes all the attorney's fees, because we've included that and collected that in the collection. That's exactly where it should be reconciled. And as of July 1st, they would owe their dues again. It'll make your life a lot easier. And we're hoping you use us for your collection, of course, but if you don't, make sure you use an attorney that counts and can accurately report to the association what they have collected. We've been keeping track of our results for the last 8 years, and the total dollars paid to the associations have totaled $7,500,000+. The time the debt was sent to us, the debts were about $4,874,000. So that means that in our collection process, we collected those extra dues. We collected the interest. We collected the late fees. And above and beyond what the attorney's fees and costs were, we still recovered an additional $2,650,779 for the associations. That's a great track record. So make sure you have a way of keeping track of all of that. And now it's going to be, there's another fine. This is going to introduce Lydia. Why do you need a fine schedule? It provides notice to the unit owner of the consequences of failing to comply. It's part of the due process, none of the above, or both 1 and 2. I'm going to let Lydia take the slides over from here. Thank you.
Very good. Thank you, Sandy. And while my colleagues that are all together and left me hanging out here by myself do the people. Hi from the Chartres home, by the way, which is a full house, and I'm surprised you haven't seen people walking behind me yet, but you may, who knows, and you may hear a barking dog, but we're going to try for keeping it professional here. So let's go ahead and click ahead and see how you guys did on this question. Oh boy, are you smart. Dan, I think you made that one too easy. Yes, of course. Well, you need a fine schedule as an association because it provides notice to the owner as to what's going to happen if they fail to comply with the documents. And it is part of due process, meaning as an association, you can't just be the Gestapo and do whatever you want all the time. You do have to give notice to your owners as to what the consequences will be if there's violations and how the association is going to handle it. So let's talk about fine schedules. What is a fine schedule? I mean, basically, in its most basic form, it is a document that lays out exactly what the fines will be for violations of your condo or HOA documents. And I'm talking about the declaration, the bylaws, and your rules and regulations. So any of those violations, if your fine schedule and your enforcement policy is written correctly, it will cover all of those kinds of violations. So we wrote this slide as a thou shalt not. So thou shalt not fine without a schedule. Why wouldn't you want to have a fine schedule in your association? We've heard boards say, you know, we don't really want to set the schedule ahead of time. We want to have flexibility so we can decide how much to fine and if a particular violation is more egregious than another one. The problem with that is, again, you're not giving notice. It starts looking arbitrary. And if we have to send Kataj to court to go enforce this for you, the judges do not like arbitrary. And Kataj could tell you about a million stories about that. And so could Dan or I. So arbitrariness is bad. You do want to have a set schedule in place. Everybody knows what's going on and what to expect. Another thing we hear is, well, we don't like following the steps in the schedule. We'd just like to do what we want to do. Again, you're going to run into problems with enforceability, and that's why we don't recommend you kind of fly by the seat of your pants as a board of directors. You do want to give notice to the owners. So get together as a board, and if you don't have a good enforcement policy together right now that includes a fine schedule, and your fines should be progressive, meaning you give a warning and then you give a fine, and it might be a smaller amount for the first violation. But you want those fines to increase if the owner violates more or continues to ignore you or whatever the issue is, because that's how you're going to get the owner's attention eventually. If $50 doesn't do it, $150 doesn't do it, maybe $500 will. So a good fine policy will be written with progressive fines. You also want to have the ability to fine on a continuing basis for continuing violations. So for example, you want your fine schedule to say every day that a violation exists can be considered a new violation by the board. This would allow you to fine daily. So if somebody puts a big sign outside their garage and that's against your rules, you don't just get to fine them $50 because maybe for $50 they just pay it to keep their sign out there, and then you're stuck. So if you can fine them every day, $50 a day does add up, and that will get you where you need to be. What else? Having an enforcement policy really does make it easier on the board. Make it easy on yourselves. Have something in place that you just open up and follow each time you get a complaint from an owner that something's being violated. You don't have to reinvent the wheel. You don't have to put your heads together and figure out how we're going to handle this one. You've already thought about it ahead of time, and you have something in place that will help you. And again, having that fine schedule in place will help those fines be enforceable in court, because the judges like to see this notice and due process followed. There's actually a case around the country, they're starting to be a little bit more emergent, where courts are dealing with fines and whether they're enforceable or not. And a couple of years ago, an appellate court, I want to say this is out in Arizona, decided that if there was no set fine schedule in advance, those fines are just not enforceable by the association. So that hasn't followed us to Wisconsin yet, but having that out there will make a difference. So make sure you've got a fine schedule. And now for our next commandment, I think we're on the third commandment, I will pass it over to Dan.
Hi, everybody. Thank you, Lydia. So the next one is have a legal document review. And I guess I'm starting this in sort of an odd place only because of yesterday. So yesterday alone, I received an email dealing with potential new law dealing with, because I don't want maintenance and repair of private roads where they don't have a written easement agreement and potential draft legislation. And I shared potential draft legislation relative to HOA law, passing its own chapter, which we've labeled 712, but keep in mind this is just a draft, but it's 8 pages long, and discussed with the legislative action committees of both the Register of Deeds, the title companies, and the real estate people, land contracts and the issue that land contracts creates for condo associations. So in this biennium of the state legislature, those 3 items are certainly being discussed and potentially passed. You go, okay, but that isn't the law yet. So I could throw a quiz at you, which isn't on our list, of, well, what was the last Condominium Act amendment? And how many of you know? And I'll bet a number of you will say, oh, the one in April of 2018, where they had to adjust the executive summaries. Hopefully, a number of you say, yeah, we did amend our executive summary because the law made us do it. And therefore, if we haven't done it, we're not complying with the law. But there actually was one each biennium. So if there was one in April of 18, there was one in April of 20. And in April of 20, what happened? In April of 20, the law changed to add 703.245, which requires effectively, before the association can sue a unit owner or the unit owner can sue the association, they have to maintain, they have to give notice effectively of the potential action and potentially a right to mediate it before we end up in court. It's a relatively long statute because it's about a page of statute language. But your documents certainly had to be amended for the first one and might have had to be amended for the second one, depending on whether they talked about filing suit against a unit owner. What I'm really saying in this third, thou shall at least look at your legal documents as a board. Ideally have some lawyer who actually knows what they're looking at, look at them, because I'm going to just go right through A, B, C, D. You're not going to know all the issues, or odds are you don't. You can probably afford to fix them, but no one wants to. We get it. It's not cheap. But if you already have your First Amendment to your bylaws and Second Amendment to your bylaws and First and Second and Third Amendment to your declaration, you've got to look through all those documents and your Articles of Incorporation and your plat and probably your executive summary to make sure it's consistent. You might want to break that down into an amended and restated bylaw so you have one document, an amended and restated declaration so you have one document, so that all of the required language, at least as needed for the declaration, is in one document, and your bylaws is in one document, as in your articles is in one document. So you end up with about 8 documents to cover everything. So we don't want to fix the issues. We get it. No one does. I don't want to fix plumbing leaks in my house, but I'm kind of stuck. We don't want to know all the issues. That's the same plumbing issue. We don't have any issues. That one I would question, because I can tell you for every legal document review we've done, which is many at this point, there are always a number of significant legal issues, just legal issues. And here's the example to make this as simple. We give a legal scorecard so you know how many points you got. Now, obviously, this one's all zeros at this point. But when we do a legal document review, we give a legal scorecard to the association along with our recommendations of what has to be changed now under the law and what they should consider doing over the next 2, 3, 4 years, our recommendations and items that maybe you don't need to change, but you should at least be aware of. And then an example of what the scorecard actually looks like and there's about 150 of these questions, is this. I know it's hard to read or it's relatively small. And on this one, I left in the legal requirements. There are lots of legal requirements, and I cite this statute. It literally tells you why each one is what it is or where it's coming from. That's the purpose of these legal document reviews, is to help you in the same fashion that your reserve study helps you manage as a board or as a property manager. It's the same thing with a legal document review. It tells you at least where you're starting from and where you want to get to. When you get there, that's up to the board. How you get there, that's up to the board. All right, and obviously the results of this, we make it subject to the attorney-client privilege, because we don't ever want somebody using it as a means to say, look at, you guys should have known about this. Because maybe you therefore did know all the stuff that we pointed out in the legal document review, but couldn't afford to fix it all yet. We don't want this being used against you. Therefore, that's why we tell you, make sure it's subject to attorney-client privilege. We do on our end. And I am passing it back to Lydia.
Okay, thanks, Dan. Let's see what we got here. Another poll question. Are you ready? Get your buzzers ready. Insurance. Is this something that the property manager should know and be able to recommend to the association? This is a kind of a true or false. First option, true. Property managers deal with the insurance all the time, and this is part of their normal job duties. Or false. Property managers cannot be expected to know all of the technical issues involved with insurance. Third option for you, false. But property managers should be able to get bids without board or committee input, so the board can make intelligent decisions. It's a little tricky. You guys go ahead and put your answers in. All right, let's see what we got. Most popular answer is number 3. False. Property managers should be able to get bids without board or committee input, so the board can make intelligent decisions. Property managers, what do you think about that answer? You're probably going, no, don't put one more thing on us. And we agree. Number 2 is the best answer there. Property managers cannot be expected to know all the ins and outs of insurance. Insurance for condominiums and HOAs is complicated stuff. There's people that know it in the industry and people that do not. And frankly, you need to give it some due diligence and pay attention to that. So that brings us to our next thou shalt not. Thou shalt not rely on our property manager to decide what insurance to buy. Here's why. So the property manager can get you bids, right? That's their job. They have connections. They can probably connect the association with some insurance agents that understand condominiums. That's great. So that'll be the property manager's role, and they can provide some bids to you. We hear boards say we don't have the time to do this kind of detailed review of insurance policies and figure out what's the best one. That's fair, because it is a lot of work. We agree with you. That's why boards, why not put it on a committee? You can certainly do that, and chances are there's somebody in your association that knows insurance pretty well, worked in the insurance business in the past, or had to deal with insurance in their job, and are probably well suited to take a look. So because insurance is one of the biggest spends that associations make, it's very important. So don't discount the job of looking at all the different options that are available to you. And you know, if you didn't know, I'm going to put this out there. I think a lot of you do know this at this point because we've been harping on it for a number of years, but just in case you missed it, the condominium statutes require that condos have insurance on everything located on that condominium property. I'm talking about the land, the buildings, and also the units that the buildings include. So if your documents say something different than that, you are setting yourself up for trouble. Let's address that very soon. And frankly, even if your documents do follow the statutes and says that the association has to get insurance for the buildings, the improvements, the units, and everything inside of there, except personal property, that's always that's the job of the unit owner to get insurance for that. But even if your documents say all this, there's still improvements that we can make to your condominium documents that I am almost positive are probably not in there, because when the developers were putting your documents together at the beginning, they weren't thinking about how owner's insurance was going to go and how the associations have to insure everything. So there are changes that we can make with respect to the insurance deductible the association has to pay, the ability to pass that along to a unit if it's only the damage is just within one unit for that particular loss. There's ways that we can tweak the language within your documents so that you can maximize the insurance coverage available anytime there's a loss. So if you have any interest in any of those topics I just mentioned, just give us a call. We'll talk you through with your particular documents how we can maximize coverage for you. And now it's Dan's turn.
Thank you, Libby. How do you invest your association's money? 1, in CDs, because Dan forgot to put the word they are a good investment and generally keep up with inflation. 2, in a savings account, because it is a good investment and generally keeps up with inflation. 3, in treasury bills, because they are a good investment and generally keep up with inflation. See the hint, 0.12%? That's the current rate on treasury bills. Not 1%, but rather 1/10 of 1%. And in a diversified portfolio with a professional manager to beat inflation while limiting risk. So I'll give everyone a chance to answer that, because I think I know the truthful answer of where the funds really are invested and then what your options are. All right, let's see how we did. And keep in mind, just so you know, I'm also the president of a condominium association, and I fight this same battle with my association. And the answer is, how do you invest your money? In CDs, it looks like 44.3%, 16% in a savings account, 3.3% in treasury bills, and the balance in a diversified portfolio. That's where you should invest it. I would be shocked if 36% of you actually were doing that. I know I've gotten our association and a couple of other associations to at least look at structured products that are now offered by professional investors so that you can hedge against a market drop. You can't completely hedge against it. Equities are at risk, but you can at least have a much better chance of keeping up with inflation, because otherwise and I'm just going to pick a number, $100,000, $200,000, $300,000 you have that's sitting in your reserve account, and you're putting it in CDs and savings. In today's money, next year, that $200,000 is $198,000, because you probably lost 2% to inflation. That's what you're doing if you're not looking for a different alternative. That's all I'm trying to say with this, is be open to some of these structured products that are out there. I'm not saying move all your money there, but we are generally moving about half over time so that they renew every 3 months in the various structured products. It's up to your board to manage its money, but at least then you have a chance of making money on your money instead of losing money on your money. All right, back to Lydia. Oh, I lied.
Where you didn't do the slide.
I skipped the whole slide. But, so here's the slide. Does it beat inflation? No. Generally, no. What options are there? Those that I sort of just went through. I mean, there's CDs, there's savings, you could put it all in stocks. That's extremely risky. Of course, there's the exception. If you have a statutory reserve account, which is probably at best 5% of the reserve accounts out there, you have to comply with their statutory requirements. But if you have a statutory reserve account, there's nothing stopping you from also having a non-statutory reserve account and investing those funds in a better manner. Is it a wise strategy? And my answer to you, if you think CDs and reserves are a wise strategy for long-term investment, is do you put your 401k funds mainly in CDs and savings accounts? And I'm pretty confident the answer there is no. All right, now onward. Sorry about that, Lydia.
Not a problem. Okay. Now contracts. Oh boy. Thou shalt not sign a contractor's form contract. We don't have a poll question on this one, but if you all were honest and we had a poll saying how many of you just sign contractors' form contracts without making any changes to them, I bet the number would be pretty off the charts. Because how many times do I see these contracts come after the fact? A manager or a board sends me a contract when something's gone wrong, and they say, how do we get out of this? And if you sign the vendor's form contract, chances are it's not going to be good for you, because who do you think that form benefits, right? It's their form. They came up with it with their attorney, and it's going to benefit the contractor, not you as the customer. And here's why you care, and here's why you have something that you can do about it. Associations, you guys have buying leverage with these contractors. You've got big numbers, usually for landscaping, for snow plowing, for contractors they want to contract with you. And it's a really good example. You know, a lot of these contractors that work through CAI come to the trade show. They obviously are putting their booths out there. They want you to hire them. So why not use the leverage that you have as an association and put some terms in this contract before you sign it that will protect you just in case things go badly. And I have to tell you a story. I think that the manager that sent this to me yesterday is on this call. I won't use any names, but I thought that I had seen it all. And the snowplow contract that came across my email yesterday from this manager, I almost jumped out the window. It was the worst contract I've ever seen for an association. But conversely, the best contract I've ever seen for a contractor. This contract, it basically said that this contractor is not responsible for any damage whatsoever that they may do in the course of snow plowing and salting and all that stuff. And it gave absolutely no outs for the association, absolutely no termination availability whatsoever. And it was a 3-year contract that they just signed last year. Well, guess what? This association had a terrible snow season, had to keep calling the contractor to come back, all kinds of damage, all kinds of owner complaints, and they're stuck with these guys for 2 more years. So how do we avoid that problem in the future? We'll go to the next slide here. Here's what should be in your vendor contracts, just generically. There should be a warranty, especially if you're having something built or repaired contractor-wise. You want to know that that contractor is going to stand behind their work and come back after a certain period and fix any issues that arise. You want payment terms. You want to make sure that they are going to work for the association. Don't just take what's offered, because you can probably negotiate those to work better with your budget. You certainly want a start date and a completion date in the contract, because otherwise the contractor might take 5 years when you thought it was going to be a 2-month job. So let's get those terms in advance and be clear about it. Insurance, of course, you'll want insurance in your contract, meaning the contractor has to provide proof to you. You have the right kind of insurance. Get all of those details worked out at the front end rather than dealing with it on the back. And attorney fees. Right? Most vendor contracts that I read might say that they get their attorney fees from the association if they have to chase you for the money and go to collections. But that's it. What if things go bad for the association in the contract, meaning the contractor's not doing their end of the deal, and you have to call your attorney? Well, wouldn't it be nice if there was a mechanism within that contract that said the association could recover those attorney fees they had to spend because of the contractor's actions from the contractor? So these are the types of things that you have the tools to do, associations. You just have to assert some of your might. at the front end when you're negotiating contracts. And it can be just as simple as having an addendum page that has some favorable terms for your association. That's your go-to, and you have it, and you always send it along with the RFPs back to the contractor saying, we like what you have here, but here's what we need in addition to it. And I haven't had any contractor, or I haven't heard about contractors coming back and saying that these are a no-go, at least not all of it all the way. So it's worth a try. So keep that in mind when you're contracting with your vendors. You do have some power and you might as well use it. Back to you, Dan.
All right. I'm going to try to go through some of the questions we've gotten, and I'm just going to do them one at a time. I'm obviously not going to say who wrote it. It says, one was, did you just say an HOA can only lien on a property in the same year as the debt? I know this was probably from about an hour ago. And the answer is not in the same year, but you only have a 6-month window, and you can't use the first 60 days because you have to wait the 60 days before you file the lien. So essentially, a year from when it came due is even too long. You have a 4-month window starting 60 days after it first came due. That's it. Otherwise, you can't lien on an HOA. Second one, what happens if the debt owed occurs in November of the current year? So we've now answered that because the 6 months still runs 6 months. Can you still collect? Yes. The third one was, what if a board is fabricating bills and sending them to unit owners effectively so the unit owner who's then refusing to pay can't run for office? Let's just start with the beginning. If a board is fabricating bills, you've got an issue, but I'm going to leave it there. You can't make up fake bills. It's really that simple. Our condo association depends on our property management company to collect dues. Property management company not collecting dues from a delinquent owner of a significant amount. What action against the property management company are you asking me about? Against the property management company can we take? Well, the answer will be, it depends what your contract says. We're not going to get into what you can or can't do in a specific instant against your property management company. I don't know what your collection policy is. The answer is a property management company, though, doesn't have the ability to sue. They have the right to, the ability to send demand letters and demand payment. But if they don't pay, generally they shouldn't get involved in the lien process, in my opinion. And generally, obviously, or specifically, they can't file lawsuits. And I'll do one. Yeah.
Just 1 second. So the questions that you were answering, I already answered in writing, and I think the attendees see the answers. So when you're looking at the list, do you see ones that say unanswered? Maybe we could go through a few of those.
Thank you.
Sure.
Got it. I appreciate it. All right. And do I have a recommendation? Was one of the ones for these structured investments? I don't have a recommendation. Here's what I'd tell you. I can give you a name of someone. I'm happy to do that. But I don't want to discount someone who you may already use, who may well have the structured products. So I would contact whoever you currently invest through. If they don't, the one I used for the one association that I'm the president of is a guy named Matt Richmond Investments in Mequon. But I'm not pushing him or not pushing him. I'm just telling you. I have another question, and then I'll get back to our slides. I have a condo association that should have been established as a homeowners association. Do you know if it's possible to convert an HOA or a condo to an HOA? And how difficult might it be, presuming municipal approval? And the answer is going to be you need to remove them under the statute 703.28. I'm pretty sure is the statute for removal of a condominium association from the requirements. It requires 100% vote, just so you know. So the answer, how difficult, is normally pretty difficult. But if it's a small association, I don't know if you told me how large, it would be then potentially easier. And we will try to keep answering questions as we go along. And thank you, Lydia, for answering as we see them. But it's nice to see everybody asking questions. So next, moving to slide, another poll question. We don't have our association pay for the board members to join CAI or attend CAI events because we want to save money for the association, avoid unneeded education as our board already knows the answers to most condo or HOA questions, avoid having the unit owners think we are getting free education on them. We never thought we should or could. And CAI, just in case for those of you who don't know, is Community Associations Institute. There's a Wisconsin chapter of it. Lydia has been on the board for a number of years. I've been on the board for a number of years. We've both been officers of this organization. It is the group in Wisconsin that oversees condominium and HOA industry, events, education, trade shows, a LAC committee being a legislative action committee to pay attention what the laws are that are going on, which I just talked to you about. So here's the answers. Let's see how we did. We never thought we should or could. The answer is you should, you can. And you absolutely should. And don't save money for your association by not spending the $267, more or less, I could be off by a couple dollars, to have 3 or all, because I think now it might be all of your board members signed up as part of CAI. It's free education. It's $267 a year. And you get the magazines, both the state and the national magazine. The national one comes out every other month. The state one comes out quarterly. It tells you what's going on. It tells you what's important. It gives you articles. It improves you as a director. That's why you can pay for it, is it actually helps your association, because the more you know, the better director or officer you are, and the better you are at helping your own association. So if you do nothing else, look what time of year it is. September 25th. I know you guys are getting ready to approve budgets. Throw $500 into your budget, or at least $300, but ideally $500 into education of the board and officers for exactly this purpose. All right, now what did I say? My questions. Thou shalt not. Try to save money by, and I'm just making sure I know where I'm going, not joining CAI and attending the events. Yes, you should. You should join CAI. You should attend events. It will make you a better officer director. Not buying D&O insurance. Wrong. It's one of the few things you can do for yourself. Why? Because you're volunteering your time to serve as a director and officer. You absolutely must, in my opinion, have D&O insurance. Ideally, a separate D&O policy from your general liability policy, which includes some D&O coverage. You want the best D&O coverage available for condominium directors, because that coverage will cover you for other weird stuff like discrimination claims, which you will sometimes get. It'll cover, hopefully, your property manager, committee members, that kind of thing as well. It is more broad than the one that comes with your general liability policy. Last one. Not buying purchasing fidelity insurance, crime insurance. This deals with people who steal money. This is, in my opinion, a must. It's generally speaking, the amount you have in reserves plus 3 to 6 months of assessments. And here's why you need it. When people steal from you, it's when you go, we have no one who's going to steal from us. That's when people steal from you. I trust everybody on my board. That's when they're going to steal from you. At a minimum, your bank statement should be going to both the president and the property manager, or the president and the treasurer. Notice the first time I didn't say treasurer and property manager, but I'm fine with that if the property manager is the one that actually reconciles the accounts. We called John. Our battery now just told me it's running low, which is a big concern because I would have thought it was charging. Get John up here. No, it's not out. I know it says that. We need to fix that. For some reason, it's not charging. And now it's charging. Excellent. Sorry about that, everyone. Small glitch. And the last one's the fidelity insurance that I briefly talked about. Here's the deal. When someone steals from you, you know the one thing they don't do that they should do, and this includes, and I'm not suggesting it with any of these property managers, but I've had it with treasurers of associations. I've had it with presidents of associations. I've had it with property managers. When they steal, you know the thing they don't buy is fidelity insurance for their association, which is crazy because if they bought it, at least the association would have the insurance to pay back the money they stole. But they never do. So my advice is make sure you have fidelity insurance. All right, now to Lydia.
All right, thanks, Dan. I'm glad we got your computer charger thing squared away. All right, thou shalt have a reserve study. Every association, definitely condominiums, maybe some HOAs too, if you've got a number of amenities and common spaces that you need to take care of. Spend the money, hire a reserve company, get the reserve study done. $2,500 to $5,000 might be a little more or less, but it's money well spent. Why? Because it's a management tool for the board to follow, for the management company to help put out there. You've got a guidepost. Otherwise, you can all just sit around and try to figure out, well, I think the roof's going to last another 15 years. But if you have a reserve study, you've got something that you can rely upon as a board. And it's a third-party expert company that's saying, this is what we do. We understand how long things last. And so they'll let you know when you have to plan to replace those things in your association, how much it will likely cost, and therefore helps you plan how much money you need to put away in those reserves to take care of those things. Then you have the reserve study done, and every year when it's budgeting time, the board can pull it out and say, how are we doing? You know, let's let this reserve study support our management decisions and our budgeting decisions going forward this year. Figure out how much you need to assess your owners. That's another really useful tool to have. And having a reserve study, because it's going to be part of your documents and something you share with the owners, will show the buyers out there that are looking for a condominium and the realtors that are looking to show them that you as an association are professional, you know what you're doing, you have your act together. There's just really no downside that I can come up with as to why you'd need a reserve study. So if you don't have one in place right now, get yourself one this year, put it in your budget. Go ahead, Dan.
Thank you. And I've got to switch back. Thou shalt not, I was looking at the question. Thou shalt not think that you know it all. I know pretty surely that other than maybe one or two people in one or two associations, no one thinks that. But that instinct of read the documents, I've been the president for a long time. I've been the treasurer for a long time. I've served on this board for a long time. I know the best way to do this is a natural instinct of most people, because you know the way you've been managing it for a significant period of time, and it has at least worked to you, for you, to the extent it has worked. But the reason earlier on we talked about all of the legal requirements that show up when we do that condominium legal document review is those literally wouldn't exist if you actually knew all that was in the statute that you're required to either do or have in your documents, or that we recommend as a best practice. And what we recommend, Lydia and I, and frankly, Kataj and Sandy, as best practices when we make a recommendation, it isn't based on, 2 weeks or a year or 2 years of doing this. This is based on 30 years. It's based on being on the national chair, the national membership chair for CCAL, the Lawyers Association. It's based on the recommendations of those attorneys, because Lydia and I, and frankly, Sandy and Kataj, go annually, certainly 3 out of the 4 of us, and normally as many as possible, to the annual law conference on what's best practices and what's going on now. We've spoken at it. We've been involved in it. So I'm not trying to say that what you're doing is bad. I'm trying to say there may be a better way, and there may be a best practice, and there may be a legal requirement that you might not know about. Committees are a good thing, especially grievance and insurance committees. I cannot stress to you enough getting an insurance committee. I know I've talked on this for at least 10 years. Insurance committees are what you need to make sure you have the insurance you really should have. The property managers, because they can't spend the time realistically, and you're not going to pay them to spend the time to figure out all of your possible insurance needs and then make all of the possible recommendations that your insurance committee could talk to in its time by having a number of agents come in and talk to it and go through the various options that are unique to your association. I think your property manager would be a great resource, but you would do yourselves, if you are on your board, a great service if you would establish an insurance committee and use the property manager as a resource to help you, but you guys decide the insurances you need, why you need them, the amounts you need, the deductibles you need, all of those issues. And then the last reason. Why would you go out and seek independent advice when you already know what you're doing? Why would you use either your accountant or your insurance agent, frankly professional, or your attorney to give you advice? And the answer is because it protects you. That's the whole point. It protects you. It protects your association. Because by protecting you, you are protecting your association. Because when your association gets sued, or you get sued because you did something that somebody disagrees with, and you'll be shocked to know there's unit owners who disagree with some things board members do, they file that lawsuit. The first thing a board member does, rightfully, is ask for indemnification that you're entitled to in many cases, most cases, under the statute and under the documents. So now whose money is being spent? Up to the deductible, I can tell you the answer. It's the association's. The association's money is being spent to defend you. Where if you already had the opinion, you could rely on the statute that I put on the slide here, 181-0850, that effectively says, if you've relied on an expert in the area who you can justifiably rely on, you can then rely on their opinion, and that's good enough, unless you have true reason to know that what he's saying is false because you didn't give him all the facts or you didn't share enough information. But that's the answer. All right, and back to Lydia.
All right, thanks, Dan. I think I'm getting ready to bring it home here with our 10th commandment that we're going to send you off with. Thou shalt not take this job too personally. Yes, there's going to be people who, board members, I'm talking to you, they're going to think they're better at your job. They can do a much better job than you. They're a pain in your butt. There's people that aren't happy and they're going to let you know about it no matter what you do. You're, damned if you don't, damned if you do kind of thing. And there's going to be people that are going through very hard times. We haven't seen this in a bigger way than we have in this last year with COVID. I mean, I can't tell you how many managers and board members that I've talked to, and it's really all the same story. They say everyone's going crazy. When we had quarantine and things were locked down, people were stuck in their condo or their home, not able to do their regular daily activities. And I think people just sort of sat and stewed about everything. And when I say everything, of course, we're also talking about the condo association and things that they don't feel they have control over, and it's all the board's fault. So don't take the job too personally, guys. Remember, you're a volunteer, right? The pay is terrible for the board most of the time, but you can quit anytime. Every set of bylaws allows a board director or officer to resign. You're not stuck in the job. If it gets too crazy, go ahead and step down and let one of these people that think they can do it way better than you have a shot at it. It's not the worst thing. And when it comes down to it, most of your neighbors are really good people. There's always those few people that Dan refers to as cave people, right? Citizens against virtually everything. And I don't know how they end up buying condominiums with shared walls. They should not. They should live out in the farm somewhere with miles between their neighbors, but somehow they end up being your neighbor with a shared wall. There's little you can do about that, but you can deal with the owners that are generally nice people and focus on the positive there. So that's your final note for positivity in 2020. How about that? So I think that brings us to the end, and I know we've got a huge list of questions here. So maybe Shayna, if you could keep my video up and also show the other three, so we're all together and sort of the best we can be.
And let me jump. Oh,
go
sorry.
ahead.
So I wanted to jump in on that cave thing because it's a perfect example, and in every association, almost every, has at least one of those people. And here's to Lydia's question, here's the answer. For some odd reason, they don't know that they're a cave person. Like, it's impossible to believe when they complain about everybody and everyone's frustrated with them all the time, and yet they think in their mind honestly that it's always because of somebody else, and they are good people in their minds. And they may be good people, but they are sometimes difficult to live with in groups. Sorry, back to Lydia.
No, it's all good. So I was just going to say, let's go through a few of these questions here, and I'll just start off. I'll read one, and then maybe Dan, Sandy, or Kataj, you can answer. So let's see.
We'll take turns. You start.
Yeah, I'm just trying to find one. Oh, this is a good one. And this, Dan, you'll probably take this. The question is about investments. Aren't you limited only to safe investments for the association?
The answer is no, unless you have the statutory reserve account. You've elected to have it, or effectively elected to have it because you made no election. So no, but should you do safe and should you do wise investing? Yes. But wise investing does not mean every dollar is invested in 100% safety, because you should do wise investing with your 401k also. And every dollar is not invested 100% safe. These structured products that are out there, and I know I've gotten a lot of questions on what kind of structured products are we talking about. They are all over the board. And they deal from investing in bonds to investing in bonds and stock to buying derivatives as part of it, which sounds crazy, but it's all to protect against a big up or a big down so that at least you can get a 4, 5, 6% return possible. Right now, it's not even possible if you're in CDs and treasury bills and savings accounts. So I don't want to spend too much time on that. Second one, and I'll let you or Kataj jump on it, was should association have their own form contract to use with contractors? I don't remember who did that one.
Yeah, me. I had contracts. So yes, I think the association should. Now, you're not going to have a contract that fits for everything you need. And I don't think it's cost effective for the association to have its own snowplow contract, because will a contractor really go with everything you say? No, they need to have some control over the terms as well. But the few items on that slide that I talked about that we think are really important for associations to have, you can create them on your own contract addendum. that would be tailored just to your association. And then you can use that form and sending it to the contractor, whichever one it happens to be, and say, we would like this addended to the end, and you both initial and sign. So it becomes part of the contract with the vendor. And if anybody's interested in something like that, you can just contact me and I'll help you out. We had another question, which I think is a really good one, because we use the terms condominium and HOA, and sometimes they're interchangeable and sometimes they're not. So the question was, we're a condominium, but we also refer to ourselves as an HOA. So what's the difference? Well, what we probably should do at the beginning of our presentation next time is to make it abundantly clear what we mean when we say HOA and what we say condominium. When we say HOA, we're referring to a subdivision that happens to have a homeowners association. So we're talking about single family homes, maybe some duplexes, but they are organized as a homeowners association. At this time, there are no statutes that govern HOAs, homeowners associations in Wisconsin. But Dan leads the CAI LAC committee, or has been a very integral part of it. And they are working on a chapter, as he mentioned earlier, to add to the Wisconsin statutes that govern HOAs that's going to look a lot like the condominium statutes. That will be a huge thing, because as it stands right now, the only thing governing HOAs is your own individual documents, and those, quite frankly, are all over the board. So HOAs, that's what we mean when we talk about HOAs. Doesn't mean you can't call your condo an HOA, but for legal purposes, when we're talking about the differences in this seminar, that's what we mean. What else you got?
I'm going to add to that. And if we talk about a condo, it's real simple. It means your documents say you are a condominium established under Chapter 703 of the Wisconsin statutes, and then all of Chapter 703 applies. Kataj stopped on one that asked, can you respond to the term statutory reserve account or statutory reserve fund? Yes. Legally, your association has to have a recorded, if you are a condominium association, you have to have a recorded statutory reserve account statement that says that you are either electing to be a statutory reserve account, have one, or not have one. If you don't elect, you automatically have one, but you still have to file a statutory reserve account statement. And what it is the easiest way would be for me to say, go look up Wisconsin statute 703.163, because it's a page and a half, it's a page, full page of what it is. But what it is in simple terms is, if you elect to be a statutory reserve account association, have one, you have decided to keep your funds in a certain fashion, safe products all the time, and if you use funds from there for operating expenses, you're agreeing to pay it back in 3 years. Most reserve accounts are not statutory reserve accounts, and therefore, if you happen to need some of your statutory funds, you don't have to pay them back in 3 years, because you used your money that was just in a different account to pay your association's debts. Hope that clarifies it. Next.
Sure. We have a question here. Someone asked, what is D&O insurance? And that stands for Directors and Officers Liability Insurance. And what that is that's insurance, that's coverage that protects board directors and officers from taking a personal loss if they are sued while serving as a director or officer on the association board. But I want to be clear in saying that only protects them from personal losses for actions taken as a director. Meaning, so if you do something outside of your role as a director or board member, if you get in a car wreck, if you get into an altercation or something like that, and you just happen to be a director or board member, that's not going to cover it. But if the board has made some type of decision and the unit owner is upset at the decision and then personally sues one of the directors or officers, that's when the D&O insurance coverage will kick in, and it should be able to pay for defending you in the lawsuit.
And for the person who asked the question, sometimes in your general liability policy, instead of being called D&O, it might be E&O, errors and omissions. It's generally the same type of coverage. They all have their own particular details, so you got to actually look at the policy.
And do we recommend, Dan, that they just go with the general liability coverage that covers D&O, or should they get a standalone D&O policy?
And I could not recommend more. And I'm telling you, ours is a small association of 16 units where I'm the president, and I would not be the president if we did not have a standalone D&O policy, because I want to be as protected as much as I can legally be protected. And that's the best way to get there.
I saw a question in there about how often an association should get a reserve study. My quick 2 cents on that would be, you can probably rely more on the reserve companies themselves because they know when things should be updated. But I'd say generally speaking, if you get a reserve study this year in 2020, 3 years from now, 2023, might be a good idea to sort of refresh or re-up. I think these reserve companies have another product where they're not completely redoing everything. It's just more of a refresh to what they already have. Is that your understanding too, Dan, of how that works?
Yeah, they recommend a 3-year, and I'm not sure what at 3 years. Truthfully, we do ours every 5 years. I think you got to know how much changed in your association, but the problem is boards always think not enough change to justify the additional expense. I would be inclined to tell you if you are 7 years out, you need another one.
Yeah, thank you. So it looks like we've got about 3-4 minutes left. So I think we have time for maybe a couple more questions. Kataj, you got anything queued up?
Sure. Someone asked a question of why have a grievance committee instead of just hearing complaints as an entire board?
So, do you want to? I'll take it. You guys add whatever you want. That's actually a really good question because it helps. So here's what really happens. What really happens generically is either the property manager or the board issues the initial fine. So having the board who issued the initial fine then being the arbiter, the decider of whether or not that fine can be upheld, kind of flies in the face of due process because they've already made a decision. The advantage of a grievance committee that does not include any board members is that decision can then be final. You can say it's final, meaning theoretically, they can't even sue and win to get a different decision. If the board finds, somebody contests the fine, you demand, the person who lost demands a grievance hearing. The grievance hearing, if properly written into your documents, is before a truly neutral group of 3 people. It could be 1, but they're generally 3 people who make the decision after hearing the testimony. So you got to give them an opportunity to be heard. This is due process. Opportunity to present their case, cross-examine the person who's accusing them. So the complainer's got to be willing to come forward and, have counsel there and present their case. That grievance committee decision can be final. And they may still sue and you may defend, but your defense is, there's a grievance committee decision. It's final. The documents say it's final. This court doesn't have jurisdiction. And you can win that. So that's why you have a different party. A grievance committee has to be separate from your board.
It is a lot easier to go into court and with that grievance committee's finding, because you're basically making the argument like, Judge, this is what the board did. They ruled this. Then we had, like Dan said, a separate uninterested party look over this, and they came to the same conclusion. And oh, by the way, in our documents, this particular unit owner signed this quote unquote contract that said that the grievance committee's decision is final. So our defense in that case would be something called, they used to call it res judicata. Now they call it claim preclusion, basically saying we're not going to litigate the same issue twice. And the first litigation took place when the grievance committee came back and ruled a certain way. So court, you don't even have the jurisdiction to hear this because it's already done. So that's the power of having the grievance committee. It makes our job so much easier when we go to court, and the judges can't really say anything about it because it's done.
The advantage of this format, I just thought of something that in 30 years of doing this, I hadn't thought of, and I want to run it by Lydia because she's sitting here listening. Maybe we change our grievance committee language to reference Chapter 788, the arbitration provision, and make them the arbitrators point blank, right in the language, and say they will become, we will have it before an independent arbitration that is selected from the members who are disinterested in our association. And judges are used to arbitration decisions being final. It may make this even better.
Yeah.
I should have probably thought of it 2 years ago, but I didn't.
We'll kick that around. See, always getting better, always improving. So I think we're out of time here. I just wanted to sign off and let everybody know that, yes, there's a lot of questions we didn't get to. Please feel free to email any one of the four of us your questions after, and we'll try to get you an answer. There was a few questions in the stack about, I believe, about the legal document review, the cost of that, how do you get that started? Please, you can email either Dan or I on that, and we will get you the basic information that you're looking for on that, and anything else you might have a question on. So is that it?
I've got a closing paragraph I'm supposed to read. We have a handout on the legal document review. We'd rather send that to you. So please email Lydia or I. It's a lot cleaner than us trying to explain it in 2 sentences. So the script at closing, which I'm going to start with, thank you to my panel members. So Kataj, Sandy, Lydia, thank you so much. And all of you, thank you for joining us today. We hope the information was helpful to you and your association or associations for the property managers. As a reminder, this program is approved for Wisconsin Continuing Legal Education Credit, has been approved by the Community Association Managers International Certification Board to fulfill the continuing education requirements for your CMCA certification. To report the CMCA hours, you need to click the CEU icon at the bottom of the screen. A certificate of attendance will be sent to you tomorrow along with a recording of the webcast. Please share it. We'd love for you to share it. And be sure to complete our short survey. We will use the feedback to put on the next one of these. So please fill it out and tell us anything we can do better. Really appreciate it. Thank you, everyone.